Hello everyone, this is Cheenu Sharma. Welcome to our third lecture of constitutional law. So in this lecture, we are going to cover three important topics. These topics are short but very important. In examination, you are definitely gonna get one question on one of these three topics, or you can even get a combined question. So property and civil rights, our first topic, then we'll talk about trade and commerce, then peace, order and good governance. Before moving with the topics, firstly let's read what syllabus talks about. So for property and civil rights, this is the fifth topic in our syllabus. Examine the scope of provincial jurisdiction. So specifically mentioned in the syllabus that property and civil rights mainly regulated by provinces, provincial jurisdiction as per section 92(13) of Constitution Act 1867. So no confusion, but there are some areas, there are some related topics, there are some related areas where property and civil rights are governed by federal jurisdiction. So we'll be talking about that. Next is trade and commerce. So explore the federal jurisdiction means specifically it is mentioned in syllabus that whenever you are going to talk about trade and commerce, there is no confusion regarding the authority. So authority here is federal. So section 91 2. Then peace, order and good governance. This we already talked about when we talked about the division of power, our third topic under section 91. The very opening words of that section talks about a residuary power, peace, order, good governance. So this is again governed by federal government. So this comes under the parliament. First topic, property and civil right. So what do we mean by property and civil rights? Firstly, let's understand the meaning of these two terms. So when we talk about property, we know that here we are talking about some kind of asset, property. It could be physical or it could be intangible. So here one thing that you have to keep in mind that under property, we are not only talking about land building. It includes tangible land building plus intangible, which we cannot see. So like example of intangible property, copyright, IP, intellectual property rights. So these are property rights. So basically these property rights ensure that individuals can own, control their possession, which is fundamental to economic stability, personal freedom, civil liberty. Next is civil rights. Under civil rights, we are talking about right of individuals to receive equal treatment. Like there should be no unfair treatment, no discrimination, and this includes education, employment, housing based on legally protected characteristics. Also, when we talk about civil rights, these are important because these ensure fair treatment, equality under law, which are essential requirements for a just and a democratic society. So, again, property rights, ownership control over physical and intangible asset, civil rights focus on protection, guarantee of personal freedom, equal treatment. So, these are the two rights. I hope till here things are clear. So, provincial power. Who control property and civil right? So section 92(13) says provinces have the authority to legislate on matters related to property and civil rights. So primary power is with the provinces but often intersect with section 91(2) that concerns with trade and commerce that we'll be talking about later on. So sometimes there is a overlap. So whenever you feel there is an overlap, there you have to use your analytical skill. There you have to find out that what are the basic constituents, how we can figure out that particular subject comes under property and civil right, and how we can figure out that particular thing is trade and commerce. So that when we'll be discussing these two topics in more detail, you will get to know with the help of various case laws, because mostly the case laws clear out things that how you have to figure out that a particular case scenario is related to property or civil right or is related to trade and commerce. but you have to keep in mind, you have to be very careful that there will come many areas where you will feel that whether this particular thing comes under 9213 or this particular thing comes under federal jurisdiction 91(2). So constitutional framers interpreted property and civil rights as encompassing the entire body of private law which governs individual relationships. So main thing that you have to keep in mind that whenever we are talking about property and civil right, this subject matter should be personal individual. So this is the first thing, first trigger that will help you in analyzing whether you have to go to section 9213 or 91(2). Next important thing, the matter, the subject area, whichever is of local and private nature, that always comes within a provincial power. Then insurance regulation. So provincial attempts to regulate insurance have been upheld by courts asserting they fall within property and civil rights. So whenever there is a law, a legislation, a rule, regulation related to insurance, here we are not talking about banking. Banking, we know that is a straightforward subject matter of federal jurisdiction. Here we are talking about insurance because insurance is a personal thing. So it's a personal right related to one individual. So insurance regulation, this is not a common, a societal concept. So whenever you will feel that something is not a societal concept, is not a common thing, is related to particular one or two individuals, that subject matter, like here insurance is a property and civil right and it comes under provincial power. But there are few insurances like marine, those come under federal power. So we have a separate list under section 91 that what all things comes under federal power. Then business regulation. General principle is that business regulation usually falls under provincial authority, but there are again few exceptions that are particularly provided under section 91 like aeronautics and banking. Any business related to these two areas comes under federal jurisdiction. Rest everything, every business of local and private nature or provincial nature will come under provincial power and it will be regulated by provincial legislation. Then profession and trade. So anything related to profession and trade, any regulation, any entry restriction, conduct rule, fee setting for profession and trade, all these things will be regulated by provinces. Like in Kreger versus Law Society of Alberta case, we saw that who had the main authority to regulate legal profession? It was held that provinces, particular province that is in question has the power to regulate that particular profession. So legal profession even, this is also related to provincial power. Labor relation, generally governed by property and civil law, but there are few industries that are of national importance, federal jurisdiction. Basically, for example, there is a company, an industry that is owned by federal government. No matter wherever that company is situated, it will be governed by federal authority. So these few little small things you have to keep in mind. Or whenever there is some national emergency, we know that everything gets controlled automatically by federal power. Then marketing. Provinces regulate intra-provincial trade, impacting local consumer, local producers, so anything related to local and private nature. But federal attempts to regulate marketing have varied with some successes and failures in court. Many times federal governments have attempted to bring forth matters before the court that okay, this particular issue, this particular marketing thing comes under our jurisdiction, but 90% they have lost the case because mostly what happens, ultimately the courts come out with the conclusion that this particular thing, this particular trade is of local and private nature, so it is mainly affecting one particular province or two particular province only. It has nothing to do with complete whole national affair. So those things, those marketing things comes under provincial regulation. Rest depends upon case to case. So here we have an area left where you can or you might feel that okay, particular thing might be get fitted to federal authority, but again you will have to see whether that thing is of local or private nature or is directly 100% affected by federal things. Next is security regulation. Provinces regulate trade and corporate security within their jurisdiction, barring certain federal exemption. So there is a federal draft bill that aims to regulate security by federally incorporated company. So here we are only talking about the companies that are incorporated, established by federal government. So there might be cases that we can consider based upon all other things that okay, this particular company comes under this particular security industry comes under federal part, but general rule is provincial part. So whenever you get a question related to property, civil right, or trade and commerce, the first thing that you have to start with in your analysis, you have to start with general principle. Then you will follow as per the facts. If you feel that okay, a fact says that maybe federal power can come into picture, then you will analyze whether that federal power is valid in this particular scenario or not. But start your analysis with the general presumption, with the general rule. So property creation, transfer, general characteristic of property right are governed by provincial law. No doubt here. Land use and planning, including landlord, tenant law, trust, will, intestacy, and land use planning. All these things are governed by provincial laws. Then there are few important cases from which we take out various principles, like Shannon versus Lower Mainland Dairy. This case upheld that provincial marketing schemes affecting inter-provincial trade. So these are of provincial nature. Then Manitoba egg reference case. This struck down a provincial scheme for regulating egg marketing, highlighting limits on provincial authority. So in this case, few limits have been highlighted on the provincial authority, the extent to which a provincial power can regulate on a particular matter. Then Re-Agriculture Product upheld collaborative scheme for national marketing regulation, like a cooperative federalism approach had been adopted here. Then Central Canada Potash versus Saskatchewan. So this case struck down provincial portioning scheme, illustrating the complexity of jurisdictional boundaries. So whenever there is some boundary issue, there is some jurisdiction issue, there is some complexity, confusion related to federal or provincial power, sometimes cases come where we have to struck down a provincial regulation if federal authority is more empowering there. Spooner Oils, a firm provincial authority for production control aimed at conservation. So now few important cases that we have to deal in detail. So number one is Citizen Insurance Company versus Parson 1881 case, very important. So here you have to understand, you have to keep in mind every single word. Then you will be able to analyze, then you will be able to take out whether here we have to go to section 92(13) or 91(2). So in 1876, Ontario enacted law which regulated fire insurance policy. So here firstly highlight this thing, fire insurance policy, then a province, Ontario. Setting standard condition deemed part of every fire insurance policy issued within the province. Legislation allowed insurance company to omit additional provision if they warned policyholder of the changes. Parson, the respondent, bought fire insurance. In this province, a person Parson, he bought this fire insurance. After a fire, when he sought compensation, the company, Citizen Insurance Company, refused to pay, citing Parsons' failure to disclose required information according to this policy conditions. Parson took the matter to court. At trial, the Citizen Insurance Company argued that this Insurance Act was ultra wide, beyond the powers of provincial government, that provincial government was not constitutionally empowered to regulate, to legislate a particular law related to fire insurance. So now issue is this Provincial Insurance Act valid under section 92(13)? Whether provincial government has validly enacted this law or it infringed section 91(2). The appeal was allowed, then taken to Privy Council. So what was the reasoning? So court held that under the reasoning, provincial government's power was not ultra vires, was not against constitution, against any law. Act regulated contract which fall under property and civil right. So contracts are personal agreements, falls under property and civil right. Two key points. 91(2) is related to trade and commerce, and it is limited to international interprovincial trade. Regulation of trade affecting whole nation, as I told you earlier again and again, something that is affecting the whole nation. Provinces can regulate contract within the jurisdiction, including specific business like fire insurance. So nothing to doubt here. Judgment for the respondent, the appeal was dismissed. Legislation was within the power, intra vires. Federal authority does not extend to regulating contract or specific trade. Then this civil property right of provincial regulation does not conflict with federal power. Very simple. So here Parson won the case, was allowed to recover the insurance amount, the compensation. Another important case, Chatterjee versus Ontario Attorney General 2009 case. So in this case, Chatterjee's property was confiscated during a search incidental to arrest. So firstly, his arrest was made. Then in furtherance to that arrest, his property was confiscated where cash and items linked to drug trade were found, but no drugs, only the items related to the drug trade. So Attorney General of Ontario applied under Civil Remedy Act to forfeit the items as proceed of unlawful activity. Chatterjee challenged this particular act, Civil Remedies Act. He said, this is ultra vires. The Civil Remedy Act, under which you have confiscated the items, under which my arrest has been made, this is ultra vires. A provincial authority has no right to enact such act that is dealing with criminal nature of law. So question is CRA ultra vires? The appeal was dismissed. CRA's validity was upheld based on court's discouragement of interjurisdictional immunity. What is the aim of this act? So Civil Remedies Act aim is to make crime unprofitable, capture, seize any crime tainted resources, compensate for crime cost. So all these things, crime tainted resources, compensate, these are matters of provincial nature. So overlapping provincial federal measures should function without operational conflict unless resolved by federal paramountcy. So here you can see that there is no need to held this act invalid, as this act is nowhere contradicting any of the federal legislation, any of the criminal laws provision. The aim is provincial nature. The constituents are valid provincial objectives. There is no operational conflict. Operational conflict comes into existence if this act works against any of the federal legislation's provision. So there is nothing which can bring federal paramounts into picture. So CRA relates to property and civil right. Here we are only seizing the property that is related to a particular illegal trade incidental to an arrest. So the seizing of property, that is the main issue, is a property and civil right as per this act, incidentally affecting criminal law without violating the division of power. So this is an incidental effect. Directly here, we are not usurping, we are not overlapping the criminal law power. We are not affecting, we are not even touching any federal power here. This is something in addition to the arrest that has been made. So here, nothing that can held CRA ultra vires. So this is how sometimes overlap comes into picture, but we have to see to what extent, whether there is a need to bring federal paramounts into picture or both particular legislations can go hand in hand and do their work individually. Next important case is Reference Re-Security Act 2001 Canada. So Alberta government questioned whether Canada's parliament had legislative authority under Constitution Act to pass the proposed Canadian Security Act. Provinces historically regulated security industry under their jurisdiction over property and civil right. Then, proposed federal act mirrored existing provincial regulation but required provincial consent to become effective. So there came a new federal act related to securities which required provinces' consent. So proposed federal security legislation would be unconstitutional if enacted. This was held that this particular act, there is no need to bring this particular act, as already securities have always been regulated by provinces. So it represented federal intrusion. So it seems like by the enactment of this act, federal government is intruding, interfering into an area that has always been occupied by provincial government. So regulation or profession specific industry type of contract, everything falls under provincial power. The pith and substance of the legislation was the regulation of public capital market participant, which traditionally was a subject of provincial jurisdiction. So this proposed federal statute do not meet the criteria of traditional test for inclusion. We cannot include this particular statute under trade and commerce as there is no need to bring this. This has already been a matter of property and civil right that comes under provincial jurisdiction. So this proposed legislation lacked the distinct federal purpose provision and intruded into an area long considered within provincial jurisdiction. So here we end our first topic of property and civil right. Next topic number 6, trade and commerce. So trade and commerce has been talked about under the Constitutional Act 1867 under section 91(2). So this section grant federal parliament authority. So authority to enact, legislate on matters that are related to regulation of trade and commerce. So despite the broad, extensive language of this clause, it has to be proven to be more restricted in Canada, so Canadian law compared to similar clause in US. So whatever language we use in US, that is more expanded one. In Canada, we use this clause trade and commerce in little restricted manner. So interpretive challenge lies in federal power. So the analysis, the interpretation issue comes where there is something overlapping with provincial jurisdiction over property and civil rights, as we have been talking about since the beginning of this lecture. So courts have narrowed the scope of both subjects so that the overlapping should be minimized, like the Parsons case we talked about. Here, the court accepted that intra-provincial trade and commerce generally falls under provincial power under section 92(13), which concerns with property and civil right. But when we are talking about federal power, where do we have to apply this? So two situations. Number one, interprovincial, or which we call international. Here we are not talking about intra. Intra can never be a doubtful question because whenever you see intra-provincial, it means any activity, regulation, interaction that occur within a single province. When we talk about inter-provincial, there comes more expanded part because here we are talking about any regulation activities between two or more provinces. So for example, like a transportation company which operate routes between Quebec, Ontario. So we can say that that company is engaged in a interprovincial trade, and here the federal power comes into picture. Then general trade and commerce, any other kind of trade and commerce that is of general nature. So on both these areas, who has the power to make a law, who has the power to regulate, legislate? Federal government. So interprovincial or international trade and commerce. So firstly, we'll see what Privy Council said, then we'll see what modern today's Supreme Court of Canada says. So as per Privy Council, the power over trade and commerce parallels the peace, order and good governance power. Both powers were initially constrained by Privy Council but expanded by various case laws by Supreme Court of Canada. Early cases indicated that laws with interprovincial character regulated broader economic aspect, like we have to see prices, labor combinations governed by economic forces transcending provincial boundaries. So areas that go beyond provincial boundaries, earlier the thing was that those areas comes under federal power. Federal attempts to use trade and commerce power to regulate marketing. This thing have been struck down by Privy Council and Supreme Court of Canada both. So on marketing aspect, we read this earlier in previous topic as well. Picture is clear. Federal power has no need to interfere. But when we talk about general trade and commerce, when we talk about interprovincial, international, then there we have to analyze which authority has the power, whether federal or provincial. But general rule is here federal, but many times provincial power comes into picture. So then we have to use our analysis. So Supreme Court of Canada in Ontario Farm Product case, federal power extended to certain transactions completed within a province. So here this was held. Why? Because at the end these transactions no matter were within a province but were of trade and commerce nature. R versus Classen, the issue was whether an act could apply to purely local operation, something that is purely locally produced. Local farm is selling. So the act imposed quotas on producer enforced through elevators and mill to ensure equal access to interprovincial export market. Manitoba Court of Appeal held act's application to intra-provincial transaction as incidental to its primary purpose of regulating inter-provincial export trade. So here what happened that although the processing, the production was completely local, restricted to only one province, but the main act under which this was completely happening had the purpose of taking this local level of production to inter-provincial level to more than one province for the purpose of export. So no matter whether production selling is happening within one province, the ultimate aim of the legislation has to be seen in order to analyze which authority has the power. So here it was held that definitely this is a federal authority thing. Next is Calliope versus Attorney General. This case confirms the Classen judgment, whatever we read in our last discussed case. Peter Hogg suggests it is difficult to discern to see full implication of these decisions as they involved commodities, grain, oil crossing provincial line. So there are few other cases like Re-Agricultural Product Marketing Act. So here a federal marketing act was upheld. Here we are not talking about any simple marketing scheme. There is a complete full-fledged marketing law statute which established a national egg marketing agency and provincial egg marketing agency, controlled egg supply by quota on each province, managed surplus product disposal, imposed levies on producer despite heavy local market intervention. Supreme Court of Canada upheld the act as a significant impact expansion of federal power into local market. So in this case we can clearly see that there was an enactment, a marketing act, but the ultimate aim was to expand the trade and commerce throughout Canada into local markets. So mainly the power has been assigned to federal authority. Next is Dominion Store versus Queen. Supreme Court of Canada struck down Part 1 of Federal Canada Agriculture Produce Standard Act, which set grade names for agricultural products as unconstitutional. Hogg criticized the decision as it rejected a modest federal intrusion into local trade that had a rational connection to regulating inter-provincial international trade. So basically in this case, what happened? Supreme Court of Canada struck down not complete act, not complete legislation, but just one part. That part was setting grade names like grade A, grade B, grade C, this kind of thing. So Supreme Court of Canada said that no, this is something related to the property rights. This is not a complete full-fledged trade and commerce thing. So here I am just striking down the part that is unconstitutional. Rest, the remaining enactment is valid. Labet Breweries versus Attorney General. Federal Trade and Commerce Powers was rejected as a basis of federal legislation. Compositional standard for beer under Food and Drug Act was struck down. The standards imposed did not consider products movement across provincial boundary, reaffirming that trade and commerce power does not authorize regulation of a single trade or industry. So the standards that were set, that were related to only one province, these standards imposed, they did not consider the overall national across provincial boundary rules and regulations, the requirements. So basically, this act did not follow the national characteristic, the federal characteristics overall. That is why the authority to put forth compositional standards for beer under the act were struck down, were held unconstitutional. Because whenever we are talking about trade and commerce power, again and again I'm saying we are here not talking about any single trade or industry. Something has to do with more than one provincial boundary, something has to do with international trade. So next area after interprovincial international trade where federal authority has power is general trade and commerce. This has not been the always criteria. So basically under general trade and commerce we see the economic nature, economic regulation. But very recently, after few cases, General Motor and City National Leasing mainly, Supreme Court of Canada has started applying unequivocally this principle. So unequivocally bring forth this principle under the federal authority. So let's look into cases. First is McDonald versus Vapor Canada, from where we take out the vapor test. That is important in examination also. Whenever you're going to get a question on general trade and commerce, you have to apply this test. So in this case, a civil remedy for business practices against contrary to honest industrial commercial usage in Canada was deemed outside federal power. So a civil remedy was deemed outside federal power. Creation or extension of civil causes of action, contractual tortious matter fell within provincial jurisdiction. We know that general application of law across Canada was insufficient to shift it under federal jurisdiction. So what happened? So here the judge bring forth established vapor test. So under vapor test you have to tick three important things. First is there should be something related to general regulatory scheme. Then a regulatory agency should oversight that scheme. That scheme should be concerned with trade as a whole rather than a specific industry. So here you cannot talk about a particular industry, you have to talk about a complete trade. So Dixon, Chief Justice in Attorney General Canada versus Sea and Transportation have added two more criteria. So these were the three criteria that were added in order to bring a legislation under general trade and commerce. So two more things have been added after this case. Number one, legislation should be such that provinces jointly or severally could not enact it constitutionally. That particular area should not come under provincial authority, neither jointly nor severally nor individually. So this is the main important thing. The area should be such that we can bring under federal government's general trade and commerce authority. Then excluding one or more provincial locality from the legislative scheme would jeopardize its success elsewhere. We have to bring that particular legislation scheme with the assent of provinces. We cannot exclude them completely. That would again go against the application. So these are the five main points that should be completed if we have to bring something for general trade and commerce. Next important case, General Motor versus City National Leasing. Competition Act was upheld, held valid as a valid exercise of general trade and commerce power. Five-part test was employed. This five-part test involving price discrimination in vehicle leasing transaction within a province. This confirmed that Parliament has power to regulate intra-provincial aspect of competition under general trade and commerce. So when we are talking about intra-provincial aspect, like in one province there is some different price, in another province there is some different price, Parliament can validly legislate on such transactions, on such areas, provided that overall comes under general trade and commerce. Whatever you are doing, no matter in one province the price is different, in another province the price is different, you are regulating separately intra-provincial matters like within the province things, but that particular legislation should be a general regulatory scheme. There is a particular proper agency that is overseeing it. It should not relate it to one industry, it should relate to a common trade. Like here we're talking about competition. Fourthly, the matter should not come under any provincial power. Fifth, the provinces should assent. So General Motor versus City National Leasing, GM sold cars to both City National Leasings and its competitors. GM was found to offer CNL's competitor better interest rate, violating the Combined Investigation Act. GM argued that Act exceeded federal legislative competence. Whether the Combined Investigation Act wholly or in part fell within Parliament's authority under 91(2), whether Section 31.1 was within Parliament's legislative competence. Here, appeal was dismissed. Constitutional questions should be answered affirmatively, that means positively. Nothing wrong here. The Combined Investigation Act is valid under federal government's trade and commerce part, particularly because it is regulating a general trade and commerce. Section 31.1 is constitutionally valid as it is functionally related to the Act. Criteria for evaluating legislation under trade and commerce power were outlined, including being part of regulatory scheme concerning trade as a whole. Here we are not talking about one particular industry. We have a proper general regulatory scheme. That regulatory scheme is concerning to a trade in general. So evaluation of provisions like 31.1, which involve assessing encroachment on provincial power, integration into regulatory scheme. So this is not a serious encroachment. It creates a limited civil right of action which is constitutionally permissible. The Combined Investigation Act is valid federal legislation and it is regulating a trade throughout the nation. So it has that national aspect which is important for something to bring under trade and commerce power of federal government. So here you can see that at every stage, at every point, we are checking all the boxes, all the 5 tests that we took out in our previous vapor test. Then application, section 31.1, while intruding on provincial power is closely related to legislative scheme, serves as core provision of the Act. Its use does not hinder the remedial mechanism within the Act. So if we use this particular Act, nothing is affecting any other remedial mechanism. So here we are done with our first 2 topics. I think most of the things have been cleared out to you. Now few other areas that are not talked about specifically directly under section 91 or 92 list. So those areas, those matters which comes under peace, order and good governance. In order to have a peaceful state, peaceful nation, in order to maintain law and order, in order to have a good government, we need few areas to be taken care of. So all those areas that are not explicitly assigned to any provincial authority under section 92, those comes under federal government's authority. So section 91 of the Constitutional Act gives federal government authority to enact law for peace, order and good governance of Canada concerning matter not explicitly assigned to provinces. So here we will be talking about 3 branches. 3 branches, 3 situations where we have to fit this part. First is gap branch, second is national, third is emergency. In examination, many of the times, almost 99% students get question related to this. So this is very, very important. Peace, order, good governance power outlined in Section 91 of BNA Act 1867 represent a residual authority that has not been talked about anywhere else, the areas that are not assigned to provinces. This means that subjects falling under POG do not fit in any other category. That is why we are assigning these to centralized government, to federal government. So POG part embodies the exhaustive principle by ensuring that all subject matters are legislated by some level of government. We cannot leave any matter unassigned. We have to assign matters. So here the exhaustive principle says that if some area, if some subject matter is not assigned to something, then we are assigning it to federal government. So this is general part. Basically, the Peter Hawkes, he says that we cannot say this POG part as a general part. This is something more than that. So basically, he said that we have to give preference to residuary theory and find residuary theory of peace, order, and good governance part more useful. He says that don't say that this is unassigned or something that has not been taken care of. No, we have to say this is a residuary part specifically given to federal government. So firstly, gap branch. So whenever there are some deficiencies, there are some loopholes, there are some gaps in the allocation of power, there comes the function of gap branch. So subject matters that are incompletely assigned by constitutional heads of power comes under POG. So there are two types of gaps. Firstly, the matters that are clearly outside Section 92 that cannot be categorized within class of Section 91. So matters assigned to either level of government but not fully legislated upon. So these things come under gap branch. Like treaty power, Section 132 of the BNA Act grant federal government power for power necessary for international treaties, but it lacks specification. So this creates a gap related to treaty negotiation. So wherever related to peace, order, and good governance, we feel that there is a matter that has to be taken care of, and there is a gap, there is some unassignment, there is some deficiency in addressing it. Those matter will come under federal government. So it's important to note that just because a subject isn't explicitly listed does not mean it automatically comes to federal government. Here, Section 91 is assigning this power of peace, order, good governance to federal government. So you have to keep this thing in mind. Like for example, when we see any matter which is unassigned but is related to local and private nature, then we go to 9216. So it does not matter that something that has been unassigned always comes to federal government. Only things that are specifically mentioned comes under that particular authority. So next is national concern, second branch. So this is important. Any matter that is related to dominion as a whole country, and where provincial powers are insufficient to address, there comes into picture the federal authority. So any matter of national concern that will get adjusted to this power of Section 91. So Russell versus Queen upheld federal statute because it didn't fit any other provincial power, suggesting it may fall under federal authority without specifying which federal power. Then local prohibition case emphasized the importance of distinguishing between local and provincial matter and those of national concern, laying the foundation of national concern branch. As I told you earlier, that the matter which are of local and private nature will go to 9216, but whenever there is some national concern, whole nation is in question, those matter will be considered under national concern branch of peace, order, and good governance. Then Canada temperance case rejected the notion that only emergencies could invoke POGG. It introduced that any law that goes beyond local and private nature matter, that is affecting, concerning a dominion as a whole, a nation as a whole, those will come under national concern branch. Like other cases, Johnson, then Munro case, all established national concern branch of peace, order, and good governance. And this I already told you, wherever you feel that provincial power are unable to address a particular issue, where you will bring that matter, you will bring that matter under peace, order, and good governance, national concern power. Now question arises, can you bring anything and everything related to national concern under this branch? The answer is a big no. There are few characteristics that has to be followed. That particular area should have some kind of distinctiveness, newness. It should not be something that has already been taken care of. It should be something new, something distinct. Like in anti-inflation reference case, it was emphasized that for a matter to qualify as a national concern, it must be distinct, different from provincial matter, and have a scale of impact. The effect should be that it's a concern of whole nation, like inflation, price rise. We know that when we talk about inflation, it is not a matter of concern for only one province. It is a matter of concern for whole country. So that is why matters like these, like inflation, which are not specifically assigned to any other area under section 91, 92, for that matter, anywhere from 91 to 95, we will bring that matter under peace, order, and good governance, national concern branch. Then, in addition to distinctiveness, it should also pass the provincial inability test. It is distinct, okay, well and good, but the matter should be such that a province cannot take up. Province is inefficient to take up that matter. Third is newness. In Queen versus Hosser, upheld the Federal Narcotic Control Act under peace, order, good governance, emphasizing newness for a reason, despite previous ruling classifying it as a criminal law. So in this case, it was held that no, narcotics is not directly criminal law. It is a branch of it, addition to it. It is a matter of national concern which is not taken up earlier. So this is something new. That is why we are bringing it under national concern branch of peace, order, and good governance. Many scholars like Peter Hogg even suggested that this newness concept is irrelevant, unhelpful, but still, time and again, these things have helped in analyzation. So we will take up distinctiveness, provincial inability test, and number 3, newness. So 1 plus 2 plus 3. If you combine all these things, then you will be able to analyze whether a particular subject comes under peace, order, and good governance, national branch or not. So national concern branch established in Attorney General of Ontario versus Canada Temperance Federation case. Judicial Committee of Privy Council rejected a narrow interpretation stating that it can be enacted when a subject matter exceeds local private concern. This we already talked about earlier as well. Then matter concerning to dominion as a whole, aviation, aeronautics, these are matters of national concern. So federal government has power, very important. In examination, you can definitely get a question related to these kind of subject matters. Then Munro, it held that any national capital region spanning over 2 provinces, Ontario, Quebec, there we can establish federal jurisdiction. Then R versus Crown Zellerbach, Canada, involved a federal regulation of dumping at sea in Canadian province, upheld under the national concern branch despite objections from the province. Because something related to even one province, if it is ultimately affecting whole nation, it is a matter of concern for whole nation, then it will come under national branch. Like sometimes we see the pollution cases, the mine cases. Then key points. So national concern branch is different from the emergency branch. Very important. In examination, you might get a little confusing scenario where you will feel that whether I should take this to emergency or I should take this to national branch. When I wrote constitutional law examination, I got similar kind of scenario where I had to figure out whether this is a matter of national concern or emergency branch. So here your analysis, your analytical skills will do the work. So national concern applies to both new and old matter, does not require an emergency. So here you should not get confused with the characteristic that we talked about earlier, newness. So if it is new, well and good, but even it is old, then it should be distinct. So it's not always that only new matters will come under the national branch, new and old both, but all the three things that I told you earlier, the distinctiveness, provincial inability test, newness, that has to be fulfilled. Then provincial inability test, matters must have singleness, distinctiveness. As I told you earlier, these things are repetitive, but examination you have to mention all these key points. Then reference re Greenhouse Gas Pollution Pricing Act. I just told you that the matters related to pollution, sometimes mining, sometimes comes under national concern branch. So this act questioned Parliament's authority to introduce nationwide carbon pricing scheme. Majority of Supreme Court found that Parliament had jurisdiction under national concern branch. Test for determining a matter for national concern was applied. So matters falling under POGG power cannot be within the class of subject. So I told you earlier that something that does not come under 91, 92, for that matter till 95, those things come under here. Recognition of a matter of national concern grant exclusive jurisdiction to be done cautiously. Recognition must be evidence-based. There is no requirement for a matter to be new. It should be distinct. So this is not an every time criteria, as Hogg also criticized. Third and last branch where we can bring this part into picture, emergency branch. Sometimes this is easy. Sometimes if in scenario the national concern aspect also comes into picture, then it creates difficult thing for you for your analysis. So emergency is something that has to be taken care immediately. So non-emergency cases, what are those? In Toronto Electric Commissioner versus Snyder, Privy Council ruled that federal legislation for settling industrial dispute was not a valid under POGG, stating that POGG power is only available in cases of extraordinary peril, extraordinary danger, emergency to Canada's national life such as war. So if there is some war kind of situation, then only that particular issue, that particular dispute needs to be taken care of under emergency branch. So this case shifted much of nation's labor law jurisdiction back to provinces. This is a simple industrial dispute. Here we can see nothing of emergency. So secondly, if there is some war kind of situation, in Fort Francis case, Privy Council deemed price control during wartime constitutional under POGG. So this is significant emergency power like war. So here POGG permit law that would typically fall under provincial jurisdiction. So we will bring forth that law to this power and we will tackle it. Inflation. So on inflation you will get many times question. So inflation, anti-inflation reference under Federal Anti-Inflation Act as an emergency measure due to prolonged period of double-digit inflation. So this is something of national concern as well as emergency concern. So here this comes under both the branches and this comes validly under section 91 POGD. So federal government can take up an inflation matter that is of immediate attention. So temporary character of law, the federal emergency power only support temporary measure because we are here, we are not doing something for the whole time, we are just doing something to tackle the situation in an emergency basis, temporary basis for the time being. Here no permanent measure has ever been upheld. So under emergency power, we can only take up matters where we have to solve an issue for the time being. What is the relation between national concern and emergency? This relation is very important. Again, I am saying in examination, chances are high that you will get a scenario where there will be overlapping between these two branches. So POGG parts serve two different functions in the constitutional, granting permanent jurisdiction. So where there is a matter that needs attention, that needs some law regulation for the whole time to come, for all the times to come, for permanent nature, There you will apply national concern branch, but not covered by specific provincial power and providing temporary jurisdiction during emergency. Here you will bring emergency thing. Then reference Reinflation Act case. Supreme Court established requirements in this case. The Anti-Inflation Act, which was enacted in 1975, this was temporary measure aimed to control inflation, which became a serious national concern. It was a matter of national concern, that is why it came under federal power. Plus, side by side, there was emergency situation to control the prices, to regulate the wages, profit, salary, fees, and dividend. So the federal government questioned where the act exceeded Parliament's authority. The court upheld that act is a valid exercise of federal government's emergency power, which includes national emergency branch. So here you can see a new thing comes into picture: national concern plus emergency branch, national emergency branch. So, but majorly because this act was enacted in order to handle a situation in an emergency basis, so it was concluded that act was a valid emergency branch, and requirements for using this branch were outlined. Firstly, there should be some rational basis for existence of an emergency. Actual emergency situation should be there. Temporary nature of legislation and an express declaration of emergency. So these requirements were further elaborated in this act, where a natural emergency is defined as an urgent critical situation, like some seriously endangered Canadians' life, like we saw the situation of COVID-19, health, safety that threatens Canada's sovereignty, security, territorial integrity. So all these matters cannot be handled by some provincial authority, because these all matters are of national concern plus emergency. Notably, there doesn't need to be a proof of emergency but merely a rational basis. So burden of proof lies with the challenger to demonstrate the absence of emergency. If someone says that okay, there was no emergency, that particular person has to prove before the court of law that okay, why that person is saying that there was no emergency. So burden here is reverse onus on the person who is stating this. So this was today's lecture. Three important topics, very simple but few basic things, as I told you time and again in between the lecture also, that you have to keep in mind how you have to use your analytical skills that are important. So try to solve the conceptual question for more conceptual clarity, revise from the lecture PDFs. Then in upcoming days you will be getting scenario based proper IRAC format questions that you will have to send me by solving. Then I will give you personal review feedback. So that's all for today. Thank you and good luck.